So when Bush redeclared it, the original had been forgotten. Defense of South Africa was justified by the War on Terror. 1988, the Pentagon declared that the African National Congress, Nelson Mandela's African National Congress, was one of the more notorious terrorist groups in the world. That was 1988, after everything that had happened. In fairness, I should say that a year ago, last May, Mandela finally was removed from the U.S. terrorist list, so he can now travel to the United States without special dispensation. But that was 1988. And in fact, the apartheid regime looked unassailable. The foreign minister's analysis in 1950 was pretty accurate. As long as they had that one vote, the world could be disregarded. Right at that time, for reasons which aren't exactly known, U.S. government policy shifted. And within 2 or 3 years, apartheid had collapsed. It's gone. That's a lot to say about what followed, not so beautiful, but it was certainly a major victory for freedom and justice. Well, those are important lessons worth keeping in mind. And it's worth keeping in mind that virtually without exception, Israeli actions and Israeli policies are in fact joint policies. They're U.S.-Israeli policies. Israel can go just as far as the U.S. permits, just as far as it supports it, and no further. When Israel does something that the U.S. doesn't like, tells them loud and clear, and they withdraw quietly. Doesn't matter who the president is. Under George W. Bush, there were some extreme examples. In fact, Israel relies much more on the United States for diplomatic, military, and economic support than South Africa did. South Africa was getting support from other terrorist states like Britain and others, Israel in particular. But Israel is really not. It's much more dependent on the United States. And it follows that any meaningful change in the relations between Israel and Palestine is going to have to be based on a change here in the United States. Now, there have been substantial changes in past years. So a meeting like this, say, would have been inconceivable as recently as 5 or 10 years ago. In fact, it wasn't long ago that when I and a couple other people tried to talk about these topics, we literally had to have police protection. And the meetings were broken up. Even in my own university, MIT, had to have police protection. Meetings were broken up. Couldn't talk about it. It's all radically changed, particularly since the Gaza attack last year, which made a big shift in attitudes and understanding. And it also means that actions are now feasible that weren't even thinkable up until recently. So, for example, the kind that were taken with regard to South Africa after decades of education and protest. It took a long time. But by 1977, Hampshire College, I think it was the first one, did pass a divestment resolution, and by the early 80s, as I say, it was even congressional resolutions. There's a crucial example, in fact, is just that, a divestment from U.S. corporations that are involved in criminal actions in the occupied territories. That focuses right where it should on our activities, focuses on us. That's what we should do anyway. Your responsibility is yourself, not other people's crimes. And it's also the decisive factor in what's going to happen. That's what we can influence. There is a Brown group, Brown Students for Justice in Palestine, which has called for divestment from U.S. corporations that are involved in criminal actions in the occupied territories. So, in other words, it's asking Brown University to keep to the law, international law, in fact, domestic law. That the actions are criminal is not really in question. The wall, the so-called separation wall, which ought to be called an annexation wall that cuts through the West Bank, as many of you I'm sure know, that was subject to a decision by the World Court, the International Court of Justice, which unanimously, including the U.S. Justice, in a separate declaration, unanimously concluded that the Geneva Conventions apply to the occupied territories. The Geneva Conventions very explicitly bar any transfer of population from the occupying power to the occupied territories. So that means any settlement anywhere in the occupied territories is just illegal. De facto in violation of international criminal law, the U.S. Judge Bergenthal declared. That includes every part of the fence that goes into West Bank territory, roughly 85% of it, which is there not to defend Israel, but to defend settlers who were there illegally, so the wall's illegal. And the same is true of every other settlement. With regard to Jerusalem, which is the area of extreme contention now, the actions are doubly illegal, and not only in violation of international law, but even in violation of very specific Security Council resolutions, which the U.S. in fact agreed to back in the late 60s and the early 70s, when the United States was still part of the world on this issue, departed in the mid-70s. But those resolutions still stand, so that's double criminality. And it was understood in Israel. So in late 1967, right after the June 67 war, Israel, when question of settlement in the occupied territories was beginning to be brought up, Israel's top legal advisor, Theodor Meron, who's a very distinguished international lawyer, he's on the international commissions, human rights commissions and so on, he informed the government that the Geneva Conventions clearly apply to the occupied territories and that any transfer of Israeli citizens there would be in violation of fundamental international law. The Israeli Attorney General seconded that. And interestingly, the person who was really in charge of the occupied territories, Moshe Dayan, he was defense minister, but he was responsible for what happened there. He agreed publicly. He said, yes, it's in violation of international law, but we're going to do it anyway because countries violate international law all the time, so we will too. And he was basically correct. He probably not consciously, but he was essentially repeating what the South African foreign minister said. As long as the master agrees, it doesn't matter if it's in violation of law. The master happens to be a criminal state anyway. And if it authorizes criminal actions, we're okay. Doesn't matter what the law says. And that goes until today. Very strikingly, in fact, rarely even gets reported. In fact, mostly doesn't. But as I'm sure you all know, the big issue, the big international issue is Iran and its possible pursuit of nuclear weapons capability. And, a lot of hysteria about that. Obama just made a big speech in which presented a new nuclear posture and said U.S. promises not to attack, not to carry out a first nuclear strike against countries that don't have nuclear weapons, with an exception. He said there are outliers, and the main outlier, as he put it, is Iran. So we can carry out a nuclear attack against them, even though they don't have nuclear weapons. Right through this period, Security Council resolutions and so on, there are other things going on. So the International Atomic Energy Agency, which is responsible for monitoring the Non-Proliferation Treaty, last September it passed a resolution calling on Israel to join the Non-Proliferation Treaty and open its facilities, nuclear facilities, to inspection. Europe and the United States tried to block the resolution, but they failed, and it passed anyway. Well, it didn't really matter. It wasn't reported in the United States or in England, and one or two notices here and there. Also unreported, except for the Mooney newspaper in Washington, the Washington Times, was that Obama immediately informed Israel that it doesn't apply to them, so they can forget about it.